I am going to be talking about PIL, public interest litigation. PIL is probably one of the most familiar aspects of the Indian legal system, even to non-lawyers. It features prominently in the newspapers almost every day. Um, Almost every political event of any importance in India tends to be covered in some form or the other through a PIL. Now, in some ways, we've got so used to the importance and prevalence of PIL, we do not seem um, to acknowledge, we seem to often forget how recent it is and how specific and unique it is. Um, so, what I'll be talking about today is the nature of PIL, its history, and its politics. Now, the defining aspect of PIL is its locus standi. That's how people understand it. That the fact um, that the that there is a change in the nature of litigation that is introduced by PIL. Um, Ordinarily, in common law, which is the system that India has borrowed from, the Anglo-Saxon system that the British introduced in India in the late 18th century. Um, the idea that only a victim can approach the court, only a person directly affected by a cause of action can approach the court, that itself is diluted. But it's not just that. It's not just the beginning of the case that gets diluted, the standard with regard to but even the you know the adjudication as is done through evidence, the weighing of evidence, the standards with which evidence is deployed in litigation gets diluted, and not just the processing of the case, the evidence, etc., but also the result of the case that ends in an order or a judgment. Um, no longer necessarily follows the standard format. So, what we'll be talking about is today is a kind of a revisionist history of PIL. By the way, this quote that I'm using here, "ये PIL क्या होता है," is actually from a film which some of you may have seen a few years back. It's this film called Sahib Bibi or Gangster Returns. It's a sequel where one particular character who's shown to be particularly politically naive is asking this question. APL क्या होता है? I mean, only somebody so naive it is shown would be asking this question. And that, in a sense, tells you how widespread the knowledge of or the idea of PIL is that only somebody who's um, a political nincompoop would ask such a question. Anyhow, so what I try to do in my work is to move the discussion of PIL and its politics away from um, a focus on outcomes to a focus on process. So PIL, and as I argue, is primarily a revolution in procedure. And I believe that locating the politics of PIL in terms of its impact on, on different social identities, the rich and the poor, the men or women or upper caste, lower caste, etc., does not really address the nature of PIL per se. I mean, what I'm trying to say is that much of the analysis has tended to focus on the outcomes and whether it has benefited the poor, etc., etc. But what I'm trying to do in my work what I tried to do was to move the focus to outcomes rather than process. Um, and I begin by looking at the history of PIL, how it arose, and and basically to question the kind of uh, the standard story, the standard narrative about the history of PIL. You know that that there was a capitulation by the emergency by the judiciary during the emergency, and to undo that, they create something with PIL. Now, my question is that sure there was a capitulation, and sure there was a kind of a legitimation crisis of the judiciary during the emergency. I mean, during the aftermath of the emergency. But why did the response have to take the form of PIL? Now, for this, you have to go back to the history of that period, in particular 1967, which was the year that Mrs. Gandhi's regime narrowly won in fourth Lok Sabha, um, but it lost the power. It lost the power to be able to make constitutional amendments because it had a bare majority. Just around then, a judgment came, Golaisi Golaknath was the state of Punjab, which said um, that the fundamental rights of the Indian Constitution are unamendable. Now, this judgment was in essence in response to the limit to the repeated use of amendments by the Parliament, the first, second, and third Lok Sabha between 950 and 967, um, and um, what this um, this judgment, in a sense, did was to say that fundamental rights cannot be treated like, I think Syed Ayatullah calls it minority judgment in Golaknath, in the plaything of a special majority. The nature of this fundamental rights do not allow or should not allow for such um, repeated amendments into fundamental rights. The response to this was a massive backlash from the executive and the legislature over the next 10 years, from 67 onwards. An attack on the judiciary as this elitist institution, divorced from the realities of Indians, inaccessible, Anglo-Saxon, too formalistic, etc., etc. And on fundamental rights itself, on rights as as the selfish individual um, rights, which are in a sense divorced from Indian realities, and all the basically the attack on right to property with extrapolated to rights in general. And this led to a certain narrative about the judiciary, particularly from 71 onwards, when Mrs. Gandhi won this famous victory and proceeded to introduce and enact a whole series of constitutional amendments um, to carry out her agenda of Garibi Hatao, etc., that she promised in 71. So there was an attack on the judiciary, particularly marked since 73, when there was the famous supersession of judges, um, and the idea that you needed a committed judiciary. The committed judiciary, by the way, the committed word is for directive principles. So the stick that the government was able to use it repeatedly to beat the judiciary with was their directive principles. That why is the Indian Supreme Court repeatedly prioritizing fundamental rights over directive principles. Um, and, and this continued throughout this period. Um, and I believe, I think perhaps many of you also would be at this point um, quite susceptible and perhaps find quite attractive this idea. So why should the fundamental rights have any priority with directive principles? Or why should any part of the Constitution have priority with directive principles? This idea, um, got deep rooted during this period in the early 70s. And at this point, I think many of you would also be quite sympathetic to that point of view, which in a sense goes against the design of the new Constitution itself, but something which is, the kind of constitutional revolution that we've seen in the last 50 years has been precisely about this turning on the head of directive principles and fundamental rights. And in this process, PIL was a very important instrument because of course the court capitulated quite spectacularly during the emergency. It not only did not stand up to the emergency regime, but it also, in a sense, completely surrendered before it. There's this line from Bhuwania about the media during the emergency that they were asked to bend, but they crawled. That's probably true about the judiciary of the emergency during the emergency as well. So the narrative goes that the court needed to respond and re-legitimize itself after that emergency humiliation that it inflicted on itself. But the ground for this, the question that I ask is, why did it have to take the form of PIL to respond to this, into this delegitimization? Now, this becomes clearer if we look at how, the nature of the court's crisis was really its inability to stand up for civil liberties, obviously. The ADM Jabalpur case in 1976, the habeas corpus case, that's what it's called. The court actually, after 77, does not try to become some kind of a protector of civil liberties to legitimize itself. Instead, it responds by actually accepting all the points of attack from the prior decade, and in a sense, accepting that role of a committed judiciary, became, as I call it, a situation of competing populisms, where the court would, in a sense, compete with the political class in prioritizing the directive principles, etc. Right. So what is often forgotten in this is that there was another way in which the court could have legitimated itself. For instance, because of the fact that the scandal of the emergency, as marked by ADM Jabalpur and Visa and all of that, there was a neat chance that it got after 1980 to reverse that legacy, when, as in 1977, all the primitive detention statutes were were repealed, except for Coffee Posa. In 1980, when Mrs. Gandhi came back to power, she promptly enacted a new preventive detention statute called National Security Act, which we continue to have. This was challenged soon after in the Supreme Court, and it was heard by by some of the same judges who were part of the habeas corpus case. Um, Now, if it really wanted the court to reverse the legacy of ADM Jabalpur, it could have just utilized this opportunity to strike down National Security Act. But the court did no such thing. The same judges, Chandrachud and Bhagwati, who were part of ADM Jabalpur, went ahead and upheld the NSA. And this has continued to be the case. I mean, each and every draconian statute in the name of national security, which imperils civil liberties, have been upheld by the Supreme Court the last 4 decades, right? From Dada, Pota, AFSPA, you name it, right? So the court has consistently been disinterested, uninterested in being seen as an upholder of civil liberties. It'd rather be seen as performing another role, which is PI. Let's come to that. Before so the general point is that the court is no longer interested in negative liberty, in protecting people from the state, rather, positive liberty through the state. And that civil liberty concerns since then have been remarkably